So welcome viewers, we have Mr. Rajiv Malik with us, and first of all Mr. Malik, welcome to Business World.
Thank you. Thank you so much.
So I want to understand from a layman's point of view, what are the basic difference and what is the importance of arbitration and mediation, and how different is it from the traditional legal system that we used to have? If you can comment over the cost factor also, how different it is from the cost point of view.
Thank you so much. First of all, before answering your question, I would like to thank this DC Conclave for inviting me here. And you see that conflict is inevitable in life, right? Whether it is in business or in society, right? Now, if we go, but the combat is optional, right? Because it is self-destructive. And litigation, especially the previous type of litigations, are the self-destructive and is this kind of combat. Right, so I would always prefer over the previous type of litigations, and I will also always advocate for the this mediation and arbitration factor, because first of all, the thing is that it is very cost effective, and it's very time management is very well, and you can have the actually the better relations between the customer and the company while we are adopting these kind of online dispute resolutions instead of following the previous type of the court litigation.
All right. And if you have to talk from the party's point of view, what aspects or what features should they look for in a mediator, and how an ideal mediator should act?
Yeah, it's also a very interesting point you have raised. Actually, if you will see, mediation, although we are following the Western idea here, but exactly it's not a Western idea. Actually, if we see, since ages, we are having the mediators. I have previously also I have talked about this topic, and I have given the example of Lord Krishna, where he was in Mahabharata, he acted as a mediator. He attempted to be a mediator between the Kauravas and Pandavas, right?
Yes.
In fact, even the pre-British era, if you will go, the Mahajans and Kulpatis and the society heads were to be the mediators, right? It is only in the British era which the problem came that the litigation became the norm of the life. So it's not a Western idea basically, but right now mediation bill is already there, so that has to be passed. And now coming to your question, that what qualities we are looking into the mediator. First of all, that he has to be the professional as per today's standard, and he should be understanding the business, so all concepts. Suppose I am in the electronics industry, so instead of having the retired judge there, right, or any outside counsel, it is always better that the in-house counsel who can act as a trained mediator, who can actually resolve the problems, because he actually understands the business. Okay. That's my point.
So a mediator should have the taste of the thing that he is going to indulge in.
Yes.
And as you rightly mentioned that in our traditions also, I think the Rashmi Rathi is also written in that only. He was being the Doot and mediator. If we have to talk from the confidentiality point of view, the arbitration and mediation, it is very important. And we have seen that in case it gets leaked and, all sort of negative comments in the media at times lead to the investors losing their interest in the company. So how important is it to maintain the confidentiality of mediation?
So it is of the prime importance, privacy and confidentiality of anything. So if we are going into dispute and litigation in the courts, everything becomes public, right? But even in fact case of arbitration also, things become public, right, at some extent. But it is only in the mediation where the privacy is maintained, and you can have the confidential information, and in fact once it's settled, it even does not go to the court or the public.
Okay, that's very so is there any global standards? Why I feel very inquisitive towards this question is because at times there are companies which are operating in different countries, right, the MNCs, right, and all. So which kind of mediation or arbitration law will apply in them if it's a dispute between two companies which have their operations or headquarters in different countries? So right, what role does the...
I do understand from where do you come from. Actually, like I'm working in LG Electronics, it's a multi-jurisdiction company,
yes,
right? And there are different jurisdictions have the different compliance, different laws altogether. right? So it's not an easy mechanism to resolve the disputes. That's why this litigation, the court work doesn't work here. So we have to rely upon the arbitration and at that time. And of course, we prefer that the Singapore as a preferred place of arbitration. And in fact, in mediation also, we have already signed the Singapore Convention on the mediation. And actually, if we should, I personally feel we should follow the Singapore and then Austria and Italy also. We can benchmark these countries, and where government actually has put lot of emphasis on arbitration, and that's why they are successful in that. So I think we should work together this area.
And if you can just point out those key parameters that those countries are applying, that we can also imitate or we can also apply.
Yeah, they are basically all the government policies and the law ministry are working towards that.
Okay.
So that's the main
collaborative effort.
Yeah, collaborative efforts is there, and then there is a good trainings are there in that thing, right? Another thing is very important discussion in this is how can we use AI in arbitration or mediation, right? This is another new concept actually there, which is very useful. And recently Apple has launched the Vision Gear headset, if you are knowing that, right? This headset is all the cost is very high, but if you will see that this Vision headgear is giving the 4DK pictures in very clarity, and any arbitrator or mediator can actually wear it and can visit the disputed site, disputed property, damaged products, accident sites. So they are sitting at the comfort in their home or the office, still they can visit that sites and actually feel it, and they can interact with the litigants. So I think that's the area where we should also work out, that AI can be a very useful tool.
All right. So as you rightly mentioned that, but one of the things which is very important when it comes to mediation is because if there is an in-person participation, then the body language and other factors also counted. And in terms of digital things can go haywire because of the miscommunication also.
Yes.
So in that line, is AI taking into consideration the emotional factor or other things also? Is there any technology on that line?
Yes, I do agree with you. That's because we are social media people right now. Yeah. So in future, maybe AI model feature will be there, and human beings can be converted to AI and just act like a robots. Yes. I personally agree. I do agree with you that it's always the one-to-one interaction is very useful. While we are interacting with on LinkedIn or social media, it's not that fruitful. But while in the courts, I must say, in fact, the recently government has introduced the concept of virtual courts, right? And so in disputes, I think AI can be used. I'm giving you a very simple example that if AI have the capability to predict disputes, and they can also predict the outcomes also. So AI can be used where there is actually no need to physically interact with them. For example, you are a consumer and you have purchased the one product, you have the defective product, you need not to interact with the judge or with the company that I need to. Your main aim is that product should be replaced or you get the refund. Yes. So that the AI can work wonders there actually.
So final question for you, if you have to comment on the role of GCs in judiciary role, because so far there is no participation, what are you saying on that?
Yes, law does not forget about judiciary. In fact, we are still not considered as an advocate under Advocate Act. Yes. We are lawyers, but as an advocate. Right. So that's the thing. Actually, we always wish that we are having so much of experience in the industry and that the company for so long we have worked, but still our grievances is that we are still not considered as an advocate. And actually, in fact, not only mediation as an arbitrator, we should be considered as a judiciary member also. Yes, I think that the time will come one day. I am very hopeful.
So is there anything in the process of
I don't think so. It is in process.
Any amendment?
No amendment is not there. But yes, people are still working on that.
Okay. So there is a pitch.
Pitch. They are already pitching government to enroll and treat as an advocate, even general counsel as an advocate.
All right. Thank you so much, Mr. Malik. It was a pleasure talking to you.
Yeah, same here. Thank you.